Corporation. Shakthi is a non-profit organization that is 501c organization. We are women empowering women. Shakthi Corporation provides a wide variety of services to women, that is such as Shakti Support Line, mentoring women new to the country and for job, and pregnancy support, food voluntary services, and community awareness events, fundraising event for a good cause, collaborating with local women organizations. And in Shakti, we have a Shakti Youth Committee. So basically, we raise by lifting others. And as we move on to our fourth year, we plan for the much needed awareness event, that is estate planning awareness session. So I extend my hearty welcome to our guest speakers for today's session, Mrs. Vimala Ramesh, my dear friend, and she's an IT consultant, entrepreneur, and financial advisor, and a founding member and board of director of Shakthi Corporation. Welcome, Vimala. And also we have Vishnupriya here with us. She's a licensed financial professional along with IT background. Thank you, Vimala and Vishnu, for joining us today. Over to you now. Thank you.
Thank you, Mahesh, for the warm welcome. And we have almost 39 participants. This gives us like a lot of excitement and encouragement for the Shakthi Corporation to do more of these sessions. Really appreciate everyone who is taking time to join this very important session, which everyone must aware of this and must have one in place. So really congratulate everyone to take a minute and to join and understand what it takes and why it is important, right? So once again, after Mahesh, I'm also on behalf of Shakthi, I'm welcoming everybody to this session. Yes, it's already like 10:12, so let's not waste any more time and get on to the session. So, for the estate planning, sorry, my throat is not good today. For the estate planning, we would like to add a disclaimer here that we are not estate planning attorneys. So you all know that we are not a legal attorneys to give you any solutions, but we are giving you all the guidance and suggestion here based on our financial services experiences and also the number of estate planning that we had worked for multiple families. So we would like to highlight that disclaimer. And if you have any questions, we would request you to note it down. And we have a Q&A session at the end of this session. So we can definitely go through every single question and we can definitely answer. So with that, let's get on to the actual session. And I would really welcome Vishnupriya, my partner, and let's get on to that session. Vishnu, a few words that you want to add before we start?
First of all, thank you everyone for having me here. And I know Vimala and Mahesh and rest of the people in Shakthi Corporation have been planning this for quite a while now, actually. And this is something everyone would need to listen to and pay attention to and make sure that they do it right on time, because we are living in a country that is about paperwork. Everything is about paperwork. So we want to keep everything in place. And for that, I'm happy that we're able to share this awareness information to every one of you. And thank you so much, Shakthi Corporation, for giving me this opportunity to share what I know and explain the details of what estate planning is all about. And thank you so much, everyone.
Yes.
And like Vimala said, again, it's definitely a disclaimer, because we are not estate planning attorneys, but unlike the popular belief where people think like estate planning is done only by attorneys and it needs legal paperwork, but it is not. Normally, you don't need an estate planning attorney to help you with preparation of your documentation, because it is as simple as you writing it in a white paper and signing it with your full consciousness. That's how much the paper is valid. So based on that, we just help and facilitate these kind of preparation for people. So we are not estate planning attorneys, and this is just generic advice or suggestions that we give to people. This may or may not suit everyone, but if you want customized suggestions, you can reach out back to us. Or if it gets even more legal, you definitely have to contact an attorney to make sure that you are on the right path. Having said that, let's go to the session already. And yeah, yes, Vimla.
Yes. So thank you, Vishnu. So yes. So for the what is estate planning? So let's go in detail. So estate planning is not just one document. Okay. So estate planning is a set of documents which secure like all your assets, where we're going to mention all your assets and liabilities. And sorry. So, I mean, who need estate planning, right? So, whoever has any of these assets or liabilities, or I would say, like, if you have $1 in your account as plus or minus, then you definitely need a estate planning, right? So, it is like everyone need estate planning regardless of visa status. Okay. So what is assets? Assets are like these are the things what we have shown in the screen, like considered as assets, meaning that whatever is like bringing you revenue out of this, that is called assets, like houses, your insurances, and intellectual properties. Like if you have any patents or anything which is going to get you any royalties, so that is considered as an asset. And any businesses which is bringing you revenues, and if you have any cash, liquid cash in hand, that's also considered as assets. And any stocks and bonds if you have, and that's also asset. So you need to put all this assets in your estate planning document. So before you start the estate planning, you need to line up all these details. You have to, put together all these details before you get onto the document. So to prepare for the estate planning, you better uh, document all this, or just at least gather what is your assets, right? And then to the liabilities. So estate planning is not about just the assets, right? So liabilities as well, like your credit card is considered as a liability, and your car is not an asset. Like many of them are thinking that it's an asset, right? But it is not asset, it's a liability. And any loans like a student loan, home loan, whatever, any loans, and any tax that you owe to IRS, right? So that is also considered as a liability. And other than this, if there is any other debt, whatever it is, any debt, so that is considered as a liability. So put together all these things, whatever you wanted to like distribute among to your family after you go. So that is what you need to like mention on your estate planning. And this is what like combining your asset and liability is called your estate. It is not like your tea estate or coffee estate that we used to hear, right? So here the estate is, this is what combining your assets and liability, what is your net worth, that is called asset, estate, sorry. That is what your estate, and that is what we are going to plan and document how we going to distribute to our dependents, or I would say beneficiaries, after we go, right? So in India there are I believe most of them here are from India. So like I'm just taking that as for example. So there is rules like after parents gone, the kids or any immediate beneficiary can inherit those assets, right? Assets or liabilities, right? But in United States, it's not going to work that way. Everything is documented. So that is what Vishnu was highlighting before. We are living in the country where everything, only the document speaks. They are not going to hear anybody talking. They're just going to look for the paper, which is like going to like tell who is going to get what, right? So yeah.
Vimala, just to add one more thing, when you said it's about the car is a liability, you are right. Exactly what it means is even your house is a liability until you pay it off.
Yes, yes,
Your
that's true.
car is a similar liability until you pay it off, because you are still paying mortgage on your car, your house. So all of this is a liability, which means if something happens to us, our kids or our beneficiaries end up paying off for those loans and then getting the rest. So if the house has been paid off, it's an asset. But if the house is still on mortgage, then it's a liability, which means you only have two choices: either to sell the house and give the money out to the bank and then take the rest, or they have to pay off for the house, finish the mortgage, and then take the house. There's only two options for the house. So be it assets or liabilities, it depends on how much we owe. So anything we owe and anything we own is our estate. And that's where the assets and liabilities come into place. And just for that is what Vimla was highlighting on what all documents we will need to start with.
Yes.
Yeah, go
Yeah.
ahead, Vimla.
Yeah. Vishnu, I think you can continue. My
Yeah,
throat is
okay.
not good.
Sure, no problem. So yeah, having talked about assets and liabilities, now we know what all we have to put into on papers. But how can we write them? Because each and everything requires customization. One paper is not good for everything. This is not all in for one. So what happens here is we have a list of documentation that we prepare, out of which the first one is the famous one, the last will. Everyone knows about will, and you have heard about will and trust, will and trust. But the will is one of the important documents in the set of documents that we're talking about, estate planning. The next one is the revocable trust. We're going to go through each and every document one by one. But before that, we want to first list out what all documents is basically required. The first one is last will. This is the final will. And the second one is the revocable trust. The third one is the power of attorney, or you call it as financial power of attorney. The fourth one is the healthcare power of attorney, because that also requires a different authorization there. And the next one is the advance directive or the living will declaration. And please pay attention, the last will is different from the living will declaration. These are both two different documentation, though they both sound alike. And the HIPAA authorization. These are all the basic list of documentation that we want to do to complete a comprehensive estate planning package. So just doing will and trust will not help to complete the documentation alone. Okay, so let's go to the last will or the testament, which is the first document. What is a will? Everyone knows what a will is on the bottom line. It's a legal instrument that details an individual's final wishes in regards to how their property and assets are dispersed after their death. So in other words, when we are living, we write what should be done to our assets and how they needs to be distributed, right? And it includes a detailed set of instructions naming the guardians and beneficiaries to a person's estate. Guardians for the kids. So we all want to live longer and we want to, see our grandkids play in our patio. That's all fine. But we don't know what life has for us. So we want to name guardians if something happens to us and we have minor kids, because like Vimala told in the beginning, this is not like India where even a newborn child can inherit all the assets and start enjoying from day one. We see in the movies, right? Oh, we have the mom and the child, we can only save only one, so we cannot save the mom, only the child is there, and then immediately the child will become the richest person in the family because the child inherits everything. But this is not what happens in this country, because unless you name all those, the assets will not go to them, and the kids, the baby also needs to be given a guardian written in paper, so that that guardian can take care of the baby. That should also be written in the paper. And beneficiaries to a person's estate. And what goes to who? Exactly what property and assets each beneficiary will receive. This is very, very important, because we have a traditional background, right? We say, oh, the son is the boy of heir of the house, so he gets the house and the assets. And the girl, because she is the girl, she gets the jewelry. So we write all of those things and we want that to give to our son or daughters. So if that is going to happen, or even be two kids and we have two houses, we want to specifically mention which house or which asset goes to which kid or which beneficiary. All of this is named in the last will or testament document. The next one is the revocable trust. I'd insist on the word revocable because there are different types of trust that people normally form. The most famous ones are the revocable and the irrevocable. As the name suggests, revocable, it can be changed anytime or revoked anytime. Irrevocable means it's written in stone. Once you prepare the documentation, you cannot change anything. Let's not talk about the irrevocable trust because the most common one we do, which is pretty safe, is the revocable one so that we can make changes all the time. What does the trust do? What does a revocable trust do is it allows the creator to maintain control of all assets within the trust. Like I told before, a minor child cannot enjoy all the assets and take control of the assets. So what we do is, though we have named guardians for the child, doesn't mean the guardian has control over our assets also. If we say the child's guardian, they can only take care of the child. In other words, that means they can take the child, they can spend their own money to take care of the child. That's what it means. They can never touch the child's money. So to avoid that, we create a trust and put all our assets and everything directed to the trust when we are not there, so that the trust maintains everything and we are the ones who name our trustees. The trustees are different than the guardians, or it can be one and the same. It is up to you. But we prepare trustees who will take care of the trust. They'll only be able to manage the trust. They'll be our known ones, our close friends, or our family, siblings, our brothers and sisters who will come into for our help if something happens to us. So these people will form the trust and they will maintain the control of all the assets until our kids become adults. And like I told, this trust can be amended or revoked anytime. And the most important thing about forming a trust is to avoid probate. Because just because we wrote all of these details in a will doesn't mean we don't face the court. Probate is a type of a court or a legal proceeding. So what's a probate? It's the legal process in which the government facilitates the distribution of a person's assets after their passing. So if the person who wrote the will is no longer there, then the normal process is, if there is no trust, that asset will be taken control of by the court, by the probate court. And the beneficiaries who are going to fight for all those assets are going to go through this long legal process because this country is complicated. We have a conservative family system here, and we come from a culture where we are very conservative mindset and we have a small family. But in this country, it's very complicated. You may have an ex, you may have a child through your ex, and you have a current marriage, and there is a relationship that somebody might have had in the past. All of this comes into play when we're distributing the assets. So to avoid all that, we form the trust so that everything is put into the trust and we name what is going to who and how they are going to be controlled. These trustees distribute property to the beneficiaries as determined by the will or state law. Either way, if we haven't written the will clear enough, then according to the state law is what all of these assets are distributed, because each state has its own law. If we didn't prepare a trust, then what happens is, though we wrote a will, or if the will is not properly clearly told, then the assets will be distributed according to the state law. Some states, they are called community property states, or they have equal benefit for both. In that case, even if one person is the primary sole breadwinner of the family, the assets will still be distributed between both of their families. That's how state laws differ. It differs from state to state. So to avoid all of this and to avoid probate is why we prepare the trust. And the process could drag on during litigation. You know about court cases. It always gets dragged for quite a long time. So to avoid all of that, we are preparing the trust. And I don't say we are going to avoid probate completely if in case we have a trust, but it just makes the process easier. If the case gets to court, we'll just say, hey, we have the trust and we have the will, everything prepared. We will take care of it. We have the trustees. And then the judge just clears the passing and then you're good to go with the assets. That's how simple it is if there is a trust clearly formed.
Yes, I would like to add something, Vishnu. So many people think that just having a will itself is enough. And they are thinking that living trust may not be important, right? So that is what Vishnu is talking now. So just like that, just the will is not enough. We better we definitely recommend to have a living will to make all these complications with the probate. As she mentioned, like it will still go through the probate, but the complications will be very less if you have a living trust in place. Okay, so remember, will is not enough.
Right. So yeah, like she said, because of the complications, they just want to make sure the assets and whatever we have and whatever we struggled for and whatever the hard-earned money that we had goes to the right person. That's where the law comes into play. So to follow that law, we want to prepare all these documents in the best way possible. And I love the system because the reason being, since everything is on paperwork, it's very pretty clear and transparent. We won't have any trouble if we follow the law right exactly as it says. And on top of all of this, there are fees paid to the representative. If we didn't appoint trustees, then if the court appoints a representative, then we end up paying fees to the representative because these are all legal agencies, registered agencies that take care of these kind of documentation and putting them into action if there are no trustees that have been put in the trust. The personal representative for the estate will first pay the creditors and address the tax obligations, which means they will take care of our liabilities first before distributing the assets. Like I told about the house, if we didn't prepare the trust or if we don't have trustees, then the representative will first come and take care of the house. Let's say we have a house with a mortgage. They will first clear off the mortgage with all the assets that we have and then give the rest of the money to us. So the debts will be paid before the assets are distributed. That's how the normal process is. But if we have our own trustees, we'll be able to make sure we plan accordingly so that the assets properly goes to the beneficiaries. Make sense? And that's generic about the trust that we wanted to cover. The next one is the financial power of attorney. Vimala, do you want to go?
Yeah, Vishnu. Thank you. Okay, so financial power of attorney, right? So this one is a legal document in which you appoint someone called an agent to manage your financial affairs. So most of us have given so many power of attorneys to the family back in India to manage our finances or properties there, to buy a property or take care of our loan or whatever it is. So most of us pretty much familiar with what is power of attorney means, right? It's a document which gives a permission to act on behalf of us, right? So the same logic here, but this is a financial power of attorney which facilitate them to take or manage your financial affairs on behalf of you. So that is what it means. So you have now have a control who can delegate somebody to act as a power of attorney. So that is what this document says. You can mention who and all can be your power of attorney, and this one is valid until you are revoking it. Okay, so unless you mention any date, it is still valid unless you manually go and revoke it. So that is what it is, power of attorney, financial power of attorney.
You normally know, right? Whenever, and since we are coming from a different country and living here, we go back and forth. We travel, we go to India, stay there for a few months, or sometimes we even plan for years together. I'll stay for a couple of years and then come back. So when we do all of that, and when we have assets in this country, we want to have somebody with the power of attorney legally who can take care of all those financial decisions. Let's say we have a mortgage to pay, and then there's something that happens to the bank account and something needs to be fixed. And we are in India, and COVID is really famous. People went in and they got stuck there. They weren't able to come back here. So during all those times, this power of attorney would have really, really helped, because somebody who is physically living here can take care of all the financial decisions. They can go to the bank. They can talk to the bank people saying, hey, I have the power of attorney. I have the decisions and the power to take any decisions on these kind of bank accounts. They can go talk to the mortgage people or handle any kind of financial decision for your family. Or people rented house here and they weren't able to close their lease before they went to India, and they've been paying rent for nothing. Nobody was there to clear up the house. Nobody was there to pay off their rent. So all of these decisions can be done with the help of a person who has this financial power of attorney.
Right. And also, like, per se, hope you have gone through this situation many times. I myself did it. So per se, my husband has a bank account. Okay. So he's not able to take care of a couple of transactions, but I'm trying to call on behalf of him, trying to schedule some transaction or wanted to get some details about it. If I call them, they are not going to answer me. They'll say that you are not authorized to get any of this information, right? So it is just like a direct, even for the husband and wife itself, they are not going to disclose anything. They are not even letting you to talk about any of your partner's account, right? So this document will give you all the authority to take care of all these financial things. Okay, so the next one is healthcare power of attorney. So this is another document. It lets you to name the person you want as a healthcare agent to make a treatment decision for you if you can't speak or decide for yourself. It does not mean that like you are in a coma and you are not able to answer to the doctors what the next step, if the doctor wanted to discuss about the treatment options, and if they are not able to directly talk to you and make a call, and they need somebody to discuss about it so that they can go ahead with the next step of the treatment, right? Here in US, doctors will not they themselves will go to the next step without having somebody to approve it, right? Because they will ended up in a legal issue if they do that way. So they will not take a chance. They look for somebody who can authorize. If you are not in a position to say yes or no, then they need somebody to yes or no, right? Unless you have this document and say, see, my wife can make a decision on behalf of me. It is not like major treatments. Even if you go for a tooth extraction and you went unconscious and they wanted to try out some other options, and or they wanted to give you some alternative treatment to get you back to the state, that time they look for somebody to authorize that, right? So those things we need to document in this healthcare power of attorney. We can say that my wife or somebody I can trust, they can make a decision on behalf of me. So that is what this healthcare power of attorney is.
And on top of everything, you don't necessarily need to give only the spouse these kind of powers.
Yes.
So let's say we have our family, our siblings who can take care of us, or no matter who we are, as long as we name somebody to authorize to take decisions on our behalf is what matters. It's really famous, right? The pregnant lady, she gets admitted, she has complications, and there needs to be some other treatment diversion that needs to take place in the hospital, and the husband just signs on her behalf. That is quite common in where we come from. But here the paperwork are different because they want to follow every single rule in this country properly. So unless there is a legal person who's been authorized to take that decision, the doctors cannot take any drastic decision to change the course of the treatment that was already put on papers before they started that. So to clear all of those things is why we have a healthcare power of attorney, to name somebody as a healthcare agent to take treatment, to make treatment decisions for you if we cannot speak or decide on for ourselves.
Yes.
And the next one is the advance directive or the living will declaration. This is different from the healthcare power of attorney. The healthcare power of attorney is you give power to somebody to take life decisions for you if in case you're not able to do that at that time. But this advance directive is us giving not the exact power to anyone to take a different decision than what we decided. In other words, this instructs your physicians and loved ones as to your intentions relative to life support, like artificial nutrition, hydration, respiration, in the event that you are permanently unconscious or have a terminal condition. This is more towards us telling how to proceed with our treatment or the next step based on our condition. This mostly goes with being in a coma or brain death situation or a serious terminal condition where the person has to go through a lot of pain and suffering, but they can be kept alive only by that. So if there's a situation like that, then we can instruct when we are in our full conscious mind saying what should be done. Say, for example, it's not stereotypically saying, but we normally think like if something happens to the husband will say, oh, keep me alive, because if I wake up again, I'll still be working for my family, I'll still be earning for my family. Or if the wife is just taking care of the family and she thinks she's not working or she's not monetarily contributing the family, the wife may think, oh, okay, I take care of my family, but I don't want my family to suffer for me going back and forth to the hospital, taking care of me, so just pull the plug. Or either way, no matter who decides, it's up to me on how I want my last intentions to be taken care of. So if I want myself to be kept in life support for as long as I want, or if I want somebody to pull the plug for me, then I have to write it on the papers. We can even say these things for organ donations. There are people who donate all the parts of their body for organ donation. You go to DMV, when you take a driver's license, they always ask this question, hey, do you want to sign up for organ donation for the state? And we say yes. If that's going to happen, then we can mention that also in the advance directive, saying if something happens to me, you can pull the plug and donate all my organs or donate my whole part of my body without giving to my family, to whoever, whatever organization we want to give. Or I want my family to follow same ritual that we have traditionally followed. It's up to you. So what decisions we make is what we give on the paper when we are on our conscious mind. That is what is all about the living will declaration. The final is the HIPAA authorization. This is the Health Insurance Portability and Accountability Act of 1996. It's a federal law that protects a person's private medical and mental health information. It's in simple words, most of you would, when you would go to a doctor's office, you would have signed the HIPAA authorization. You would have just put the date and the signature in the bottom of the paper. Not many of us would go through the paper. What HIPAA authorization means is it gives the right or not the right to anyone to access our private medical and mental health information. And this HIPAA authorization that we give to someone is very, very important, because we have the right to say that this person cannot access the medical records, and we also have the right to say this person can access our medical records. Because if something happens to us, let's say we are traveling or going on a long drive, something happens at that time, some stomach upset, or we go unconscious for no reason and we get admitted in the hospital in a different place, and our network doesn't cover any of those hospitals. At that time, when those doctors demand our records, they cannot just like that pull those records. There needs to be somebody who give the HIPAA authorization on our behalf and say, hey, this person can take all those documents on my behalf and you can access my records to this person. If we give that authorization, then wherever we go, the person whom we have authorized can access these medical records. You can even mention whether they want, they can access the mental health information, as in called the psychotherapy notes. Because these days, stress is quite common. We go to the therapist, we go to psychologists, we talk a lot about everything. So it is up to us whether we want to include all those details in the record or not. We can even mention that. And let's say I want anyone to access my private medical information on the HIPAA authorization like I've gave, but I don't want them to access my mental health information. You can also write that too. So it depends on what you are adding to the HIPAA authorization documentation, so that it's completely taken care of. And again, even in this document, you don't have to necessarily give only the spouse. You can add anybody in your family or your loved ones or your friends. It depends on whom you are comfortable with sharing all those details. You can even add a close friend that you've been in touch with since your elementary school, and you say, hey, this person can also access my information. It's up to you how you want to set it up. But we have to set these in paper when we are fully conscious, so that these documentation are completely valid in court. And having said all of these things, all of these paperwork, they don't need an attorney basically, because you are preparing with your full consciousness. But all it needs is notarization. You have to get all the documents notarized so that these documents are completely valid in court. So this authorization is a document that designates a person who may receive another person's private medical and mental health information. So having said about all of these things, and we talked about assets and liabilities in the beginning, but what is your part of your estate in detail? Anything and everything that we own and that we have, even on paperwork. So, excuse me, I think somebody has access on the sheets. Okay. So parts of your estate called your 401ks, or which you call the retirement plans, your IRAs, your Roth IRAs, your 403bs. All of these things are different kind of retirement planning that you do in this country, like your PF or your PPF in India. So all of these things are a part of your estate, which means if the person who's working, let's say with an employer has a 401k, that money also becomes a part of our estate. Your home, your personal belongings, your jewelry, your bank account, your investments and the returns, your capital gains, your stocks, bonds, everything. All of these things is a part of your estate, which means to protect all of these, we have to prepare a comprehensive estate plan and document instructing what needs to be done for all these documentation to be distributed to your beneficiaries. And depending on the state that we are living in, these documents may even need to be registered in the county court saying that we have a trust formed and we have these documentation ready so that you can implement it if something happens to me. We want to do all of these things and register and make sure we have the copies with us and also distribute it to our close ones so that they have access to this document as a copy so that they can show that when the situation comes. So okay. So to finally summarize everything that we have told, prepare these documents with the help of somebody who can guide you. I know we told in the beginning that you can write it in a simple paper and then sign it and get it notarized and that paper is fully valid in court. But to exactly know what needs to be put on those papers to completely cover, it is always good to take in suggestions from someone, follow everything by law, check the state law, what is happening in your state and what laws are passed and how to prepare a legal estate planning document and how to get it notarized. Or depending on the state, whether you have to register with a county, there are different sets of steps that we want to follow for each and every state that we are living in. And on top of everything, if we move from one state to another, we again have to go through these estate planning documentation. Again, make sure that those documents are changed and altered based on the current state that we are moving in so that we have these documentation up to date. So start planning right now because estate planning is something very, very important that's going to be in force from this moment until the end of our lives and is going to carry forward to our next generation too, because a lot of these documents are fully valid to our following generations also. So make sure that you prepare all these documents, plan for your present to save your future so that you can have a stress-free life for the rest of us. Thank you very much. And that's going to be the end of our slides. And if you have any questions, please free to reach out to us. You can reach out to Vimala or anybody in the Shakthi Corporation, or you can call or email me directly if you have any questions, so that we make sure that you prepare your documentation perfect and you have everything good in place.
Yes. Okay. Thank you so much, Vishnu. Okay. So we have quite a bunch of questions here.
Questions here.
And go on to what? Okay. So the first question is like, what is the purpose of adding beneficiary to the bank accounts? Is that not useful?
It is definitely very important to add beneficiaries to your bank account. But on top of that, again, like I told, if you have added beneficiaries of your kids in your bank account, that means whatever is in your bank account goes to the kids directly. So instead, when we form a trust, we direct all of those things to the trust, which means instead of the beneficiaries directly being added to your bank account, you can add the trust to the bank account, calling it a beneficiary, so that when we are not there to access our bank accounts, the bank account money will directly go to the trust and the money will be distributed to the beneficiaries through the trust. That's the safest way possible to access your bank accounts if the person is not there.
Yes. Okay. Where do we register these documents?
Okay. So basically, for most of the states, a simple notarization is good enough. You talk to your friend who's a notary public, or you go to the bank to get it notarized, doesn't matter. As long as it is notarized, it is fully valid. But in some states, you need to go to your county court and talk to them about registering that trust. You don't need to register all the documentation, but the trust documents need to be registered. You can just generally ask them, yeah, I have all these estate planning documents, and how do I register? Sometimes they would say open, when you open a business, you register that with the state, right? So just like that, you register the trust with a tax ID. And once that is generated, you can start giving that trust with that trust tax ID to all of the place where they're asking for beneficiaries, like your bank account, your life insurance contract, your 401ks, your house. For all of these things, you can give that registered document and the tax ID to be registered, which has already been done with the county. So it depends on the state that you're living in.
Yeah. Thank you. And the next one is how will the doctor know if advance directive or a healthcare power of attorney is present for the patient who is not able to communicate?
So again, all of these documents are there in place. And that's why I mentioned, once you completely notarize and get these documents ready, send copies of these documents to those people whom you have mentioned in your document. Let's say I have like 3 or 4 trustees that I have put on the paper, and I have like a couple of guardians for my kids. Distribute the copies of these notarized documents to all of those people so that they can show this document to the doctor at the time of the situation, so that they can carry forward what we wrote in the advance directive.
Yes. So
And,
you
and
make
it's good
sure
to
that you
talk
have
to people about it. Always
yes.
talk to your close family friends. Keep them on the loop. Tell them everything what's happening around you so that they are aware of what needs to be done. We have seen our grandparents talk to us all the time. Oh, I'm done with everything. Just, I want myself to be buried or burnt in my native place. They keep telling us all the time. Just like that. So try talking to your loved ones so that they are aware of all these things, and give copies of these documents. Don't give the original. You can keep your original with yourself, but the copies of the documents, the updated copies. So every time you make a change, again, prepare those documents, send copies to the respective people so that they know what to do at that time.
Yes. So you always make sure assigning multiple people as a trustee, and keep at least one person who can reach you very quickly, and other people, like you can keep other couple of people, like they could be from your family or trustable person. All right. And make sure you're, as Vishnu mentioned, make sure that you're passing these documents to them, and discuss with them like what you wanted to do and what you meant in this document. Because just by sharing the document, they could have got it and put it in the back pocket, right? And when the situation comes, they probably may not know. Nobody has the time to read what is in that. So you better I mean, we are taking time and discussing all the picnics or trips, right? So I think this is more important to take time and discuss, go through the document and make sure they aware like what is your wishes, what you wanted to do with your assets, your kids, with you personally, and discuss with them. You are not going to discuss with everybody, right? It's just the limited group who you trust, right? So discuss with them and make sure that they are in line with your expectation. And also remember that when you do a revocable trust, you can change the trustees later if you wanted to. It is not like set in stones. So when you assigned some set of trustees, you can change them later point as well. Okay. Okay, hope that answers. Okay, so let's move on to the next one. It is how much does these documents cost? And is it one-time cost or recurring fee?
Okay. So see, like I said, you can write it on paper and sign it and get it notarized. Okay. But to follow all the legal questions and legal things that we want to include, it is always good to take care of some paperwork or some assistance from someone. So for that, you may pay a little bit of a fees here and there. But if you go to a full size legal attorney, estate planning attorney, the charges differ because it goes along with the consultation, the preparation of the documents, and all of those things. But if you have somebody to help you, there are packages available everywhere, and people like us, we can assist you in filling those documentation. So the cost comes to a very bare bottom where you just pay for the package and then you prepare the documentation. But having told about these packages, there are like variety of packages. You go online, there's like list of things that come and you get a package even in Costco, and Costco is really famous for even for that. So, but putting all these documents in place needs for you to know what are documents and how good they are. And because these documents are all state specific, it is good to talk to a financial professional or a professional who can help you with the estate plan and documentation, and then prepare accordingly. And for the cost, it differs. It can be as less as like $300-$600, or it can go, when you go to an attorney, they may even charge you thousands of dollars to prepare all those, based on the complexity. It depends on how complex you want to prepare the documentation, because we have businesses now, we have assets here and there, and there are a lot of people who do business in between India and the US. We think like selling these sarees, jewelries, and bringing it here is a simple thing, but no, it's not. You are actually importing a lot of stuff from India to here. That means it's a major business also. So which means if things like this is going on between two different countries, it depends on the complexity of the documentation you want to prepare, and based on that, the cost differs. But to ask if it's a recurring fee, it depends. Like if you want to have a package, they may have a recurring charges, or sometimes you can just use the package for runs and keep it safe. And whenever you want to edit, you can pay a little bit of a charge and then edit it at that time. Or if there is no edits, you just pay a one-time cost. So it depends on how you want to set it up. But as long as you take a suggestion or consulting through somebody who can help you with those documentations, then that's great.
Yeah, and to add to it, few employers like Wells Fargo, they are providing legal coverages like Arag Legal or something. Through that coverages also, they are giving an option for you to like get this done, estate planning done. But only thing is, all we are saying is make sure you are having all these documents or getting it done by them. So make sure not just the will, make sure that you are getting done rest of the documents as well. That is what all we are trying to update you here.
To be precise, so far, I'm just saying about through my experience. Again, like I said, we're not legal estate planning attorneys, or we don't have like on the dot information. It's just generic information. So far that I have seen in my experience, a lot of legal plans do not offer trust, or you have to pay an extra cost for the trust. And as long as that employer covers you through the legal plan, you are good. But if you get out of that employer, and if your current employer, or you move into a business and now you don't have the legal plan, if you want to make changes to your documentation, you again have to go to an attorney and again pay extra fees for that. So to avoid all of that, make sure you choose the right person to talk about all these things and reduce your cost as less as possible. Because if you can get the same thing for a lesser price, why pay more? So make sure you talk to someone before you start all of that. And to your legal plan, check with your employer about all these documents, whether they cover fully. And then if it covers, just go ahead and do it. That's the best way possible, because it technically covers everything.
Yes. Okay, cool then. Hope that answers. And the next one is, how can we add future assets and life insurance to will and trust if it is already notarized?
Good. So future trust, like I said, this is not, it's a good thing and a bad thing. Okay. This is not like India, where we have to keep amending our trust every time when we add future assets. Here, the documents are prepared in a more generic way, which means as long as I'm alive, I have every right to enjoy what I own. But after me, whatever was on my name goes to my family or the beneficiaries that I have named. So the trust generically protects everything that we own at the time of our death. That's what it means. So for future assets that you buy, or your life insurance policies, or whatever solutions that you buy financially also, you can add the trust once you register it. You can put that trust as a beneficiary in all those documents, so that anything that happens, and then all of these things will go to the trust directly. You don't have to keep mending. Or if there is something like a house that you buy and you want to give it to your kids, and you buy a new house, sell the old house, and if you want to really put it in the document, then you can add it and again edit it, again get it notarized. So this is the main reason why I told, if you are going to a legal plan or an attorney, you have to keep going every single time if you want to make changes. And there are good packages that actually allow you to do the changes within your own control by yourself. So try talking to a professional so that they can help you with all these changes also. But in short, every time you make a change in the documentation, you definitely need to get it notarized again.
Perfect. Okay, so along with that, there is another question. Should we notarize the documents in all the states where we have assets?
Good question, actually. So I know we move from state to state and we finally end up saying, hey, you know what? I have a house in that state and I want to include here. Your resident state is what matters. So you can technically put your house in a different state into your estate planning document here, because your resident state is that. As long as you're paying taxes and your residency in a single state, you can prepare your documentation based on that state.
Good. Okay. So can we have more than one guardian or more than one agent? And can we change that will at any time?
Definitely. You can do all of those things in a documentation, because normally when what we do is, before we started creating these awareness, before we started understanding what estate planning is all about, we would have prepared a simple will saying the beneficiary would be our parents. Right? If something happens to me, it goes to parents. But technically, it doesn't sound right, because they are previous generation, right? I'm talking on a understanding practical theoretical way of work. It cannot go from us to them. It can only come from them to us. That's how the generations work. So in that case, and in a lot of different aspects also, we may have put some friends whom we would lose touch over a period of time, or something happens in the relationship between us, or somebody dies, whatever, whoever person we put on the as a guardian or a trustee, they may have died during that time. So you can do all of the changes in these documents, and we would definitely recommend, if you are putting those things in a document, put more than one guardian, so that if one guardian is not able to come or help at that time, the other person can take care of it. And that applies to the agents also. No matter you put it as a healthcare agent, the trustees, it is better to put more than at least 2 or 3 people in the documentation, so that they can take turns, or anybody who can assist at that time can directly come and help you out. And you can definitely change the will at any time. As long as it is your will, and as long as you're in a fully conscious mind, you can definitely go ahead and edit it whenever you want.
Yes, definitely keep more than one.
Yes.
Yes. So can we add our family members who is living in another country as a trustee beneficiary?
Absolutely, yes. Because no matter where they live, there are families. Just because they don't live in this country, I cannot put my neighbor there.
Yes.
Right? So you have to put your family, your loved ones, or your close
Your
friends
trustable one.
whom you trust. Trust,
Yes.
it needs trust. That's it. To put your name in the trust, you need to build that trust with that person. So of
Yes.
course, you can put family members living in another country as a trustee beneficiary, so that they can come in. But make sure you don't let a gap, because if they are living in a different country, it may take time for them to come to the US if something happens to us in the US. And during that time gap is what a lot of things may happen. And I wanted to mention this. I know it's going to sound alarming, but this is what is going to happen if something like that happens. If something happens to the parents, the first thing that will happen is the court will take control, and then the kids will go to child services. That is something that happens in this country if we don't have somebody to come take care of the kids as guardians and trustees right away. So we want to make sure we don't leave that gap. So if you have somebody very close living in this country or living in your same area that you would spend your weekends, evenings, you do parties, potluck, you call them for your functions, you call them for your Navratri, all of those things, put that person in the trust also, so that they can take care of it right away when something happens, and they will hand over those things to the person from your family when they come from the other country. So just have a mix of all these people put together. So it's up to you how many other people you want to put in this, in those documentations.
Yeah. So whatever we are striving and saving, we are earning, everything is for our loved ones and our families, right? So make sure that they have been taken care properly after us. So please keep that in mind. We are seeing so many GoFunds recent days. Okay. There is another question, same thing. Can the trustee member be in India, not in this country? So which we already answered. It is definitely yes. Also, do we
Yes.
have an option to add husband as the first beneficiary for everything and then add the trust as a second option?
I would say it is not a good option. I mean, you can see, this is end of the day, it is what you put in the documentation. You can write XYZ and then make it as a legal document. That's not a problem. But always having a single person as a beneficiary directly will create a lot of trouble. So to avoid all of that, it is better to direct everything in the trust. But you can choose the option. There are options in the documentation where you can say, hey, if something happens to me, I can have all the assets go to my spouse first, and then if the spouse is not there, then the asset goes to the trust or the beneficiaries. You have that option there. Of course, because if there's a spouse and you are married and filing your taxes jointly, you are living together in the same house, you are legally having a marriage document, then of course you can put the husband or the wife. It doesn't matter there. But putting it in a trust always protects and avoids a lot of litigations and court cases in the future, so that everything is put in the trust safely.
Yeah.
But
Okay.
by default, yes, if something happens to the wife, the money first goes to the husband. But you can also say that if something happens to me, I don't want my husband or wife to take care of the assets. I want them directly going to my kids. There are also options for that. So it depends on how you want to prepare the documentation. Anything is valid there.
It's all your wish. How do you want to execute that? But it's
Yes.
option. It's there. Okay. So can we include assets in India in this will?
Technically you can, but we don't advise it. We don't recommend it, because each country has different set of laws and rules. So to avoid all of that, keep it to each and every country's assets to itself. I know it's a long process. You have to do it here and then you go to India. Instead of spending that one small 30 days of vacation going back and forth between cities with an attorney or lawyer there, I know it is tough, but still go ahead and do it, because each country has different set of rules. And us coming here, we don't want to come here, live on the visa, again go back to India. People who come on a visa turn into green card holders and then turn into citizens over a period of time. So when you go back to India again, there may or may not be an easy process to go through all of these documentation. So always prepare your assets in respective countries with lawyers in those countries, or however the legal process is for that country. It is always good to follow the laws as per that country, and always register your estate planning documentation, your will, your trust, or whatever documents is required based on the country wherever the asset is located.
Perfect. Thank you, Vishnu.
Mm-hmm.
Okay. Okay. There is multiple requests to share this slide. Yes, we will share all the participants. Okay. Okay. And then do we need to add more than one person for trust? Yes, we already answered. Yes, we recommend that. And then is it required for trustee a need to be physically present to execute the will?
Trustee to be physically present to execute the will?
Yes.
No. The trustees need not be there. And on top of so execute the will as in when something happens at that time, is it? Is that what that Harshan, are you asking if in case there's a situation that the person is not there and they're executing a will and the trustees needs to be present? Is that what the question is? If that's what, yeah?
Yes.
Okay. So yes, then yes, of course, if something happens to us, then we are not there. So somebody needs to be physically there to execute the will. That's why I said, have a person whom you trust in this country, in your own area and city, so that they can come in directly, write to your assistance if there is a situation. And then your family members whom you have put in the trust document along with that friend, they may take time to come from India or UK or Australia, wherever they live in. They may take time to come in here. Or people living in India right now, though there is awareness, I have seen families whom their immediate siblings and parents don't even have a visa yet to even travel to this country. And at that time, they will process their passport, they'll process their visa. It's a lot of processing going on. So to avoid all that, it is better to have somebody physically present here so that they can take care of it first. And once your family members pitch in, then they can transfer all those authorities to that family member, because those names are also there in the documentation.
Thank you. I was thinking maybe with all the virtualization, there may be some options. That's why the reason for that question.
No, virtualization is good enough to prepare the documentation, but to execute it, you need somebody to be physically there, because the moment something happens, the police comes in, the court takes care of it, and the court would need to see the person physically there to take care of it.
Makes sense. Thank you, Vishnu.
Yeah, sure.
So to form a will and trust, you don't need them to be physically present, but to execute it, yes, we need one of the trustees to be in person to say yes or no to whatever the situation is. That's why we always recommend to keep one person who can jump onto any situation right away. So
Right.
keep one person very close and to handle the situation.
Okay.
And to add to what we were talking about before, though we prepare these kind of documentation here in the US, in India, we have this religious thing, right? Because each religion will have its own set of laws. We have the Hindu marriage law, and we go to the Jamaat to register the Muslim registration, or the church, the diocese will take care of the registration of the marriage and rest of the laws for the Christians. So we, each and every religion, they have their set of rules and laws. So for all of that, in India, a simple death certificate and a legal heir certificate is good enough for you to access assets directly. But that is good to happen if the person is a citizen of India. And it changes if you are no longer a citizen of India, and if you have renounced your citizenship in India and you are a citizen here, that's when you would require a legal documentation with the help of a lawyer, where you prepare your assets in India for yourself to come to your kids or to yourself. So having said that, in India as such, a lot of people may not have prepared a will yet, but it is always good to prepare the will, because if I'm a citizen, then it's quite straightforward. I have a legal heir certificate, and then I have a death certificate of my parents. I'll be able to take all their assets for myself. Or if I have a sibling, we'll be able to distribute it ourselves. But if you're no longer a citizen of India, that's when I don't say it will come, but we don't know how the laws change in this country frequently. So we just want to be safe. So I wanted to add this here because I saw the question about preparing will separately for in India. So I want to add this here.
Yeah, thank you, Vishnu. It's already 11:10, so we have a couple more questions to take care. We can answer those questions. And if you have any more question, you can either reach out to me or Vishnu in person. We are happy to assist. Just to consider everyone's time. Okay, so yeah, let's go to the next question. Do married couples who have shared assets and liabilities need separate trust? That's a very good question.
It again depends on the state. So some states allow you to prepare a joint trust. Most states will say you can prepare a joint trust, but I would recommend, if your state follows that law of having separate trust, make it separate. You can have one trust to be registered, and you can direct all that asset to be going to that one trust. That you can do. And in normal family lifestyle, they would normally put the husband if he is the older one. So put the older one's trust in force and prepare the documentation accordingly, but always prepare both the trust if your state requires that, because the laws are different in each state.
Great. Okay. The next one is healthcare power of attorney, HIPAA authorization, advance directive. Do we need one of them, or all three are required?
All three is required. There is nothing called all in one. We require each and every documentation for everything.
So all the 6 documents we mentioned, everything is required.
Yes.
Just in general, not just 3, everything is required.
This is not like your basic sauce that you prepare in a paneer butter masala and then change it to chana masala, right? We live in a country where each and every single documentation is customized. So, and it is very, very shortened up and precise, so that there is nothing that goes wrong for you. This is a more legal country where it protects each and everybody's rights and responsibilities to the dot. So to make sure that we do all of that, each and every document serves a different purpose. So you always prepare all these documents.
Good. Okay. So the last question, if we have multiple trustees in our trust, then do they all need to be available in person to execute the will?
Not necessarily. It depends on how you want to put it. Whether you want all the trustees to be there to jointly take care of it, or whether you want the trustees to take turns one after the other. It depends on how you want to set it up. Like I said, you can customize your documentation based on your will. That's why it's called a will. And based on your trust that you have with people. So you can have multiple trustees, and if you want all of them to be there, you can write it so. But if you don't want it, you can say, hey, I need one by one coming after the other, if in case one person is not available.
Vimala, I'm talking on mute. Yeah. Okay. I think that's all pretty much questions. And I mean, this is really like an engaged audience. Really appreciate that.
There's one more question. It's just a shorter question. So just to clear it off, I think Rajkumar asked if in case if we missed anyone like HIPAA, can we add it at a later stage? Of course, yes. It is your will. So as long as we are in a conscious mind, you can add or remove any documentation, any name, any trustee, any guardian, no matter what you want. But the only bottom line is every time you make a change or addition, always again get it notarized or follow the law that is followed in your state. If you want to get it registered again, you can do it registered, and you can revoke the previous one if it is no longer valid. There are 3 steps that is required based on the state that you're living in. So yes, you can add or delete whenever you want.
Yes, and not just HIPAA, all these documents are editable, changeable. So, I mean, based on your current situation, if assign one person and they are not close now, and you can change any of these documents with anybody's name anytime. And as Vishnu said, make sure you are notarizing it and legally protecting it. So that is what you always need to remember. Then only it will be valid. Okay, so I think, yeah. So with that, if you have any more questions, feel free to call us, and we will be sharing this recordings as well as the slides to all the participants. And once again, thank you to all the participants. Over to Vidya from the Board of Director of Shakthi Corporation.
Thank you, Vimala. Thank you, Vishnu. This was such an informative session. And I cannot actually thank you enough, because even though most of us think we are extremely, we are educated, we know so much about certain things. I think when we come to this country, there's so many things that probably we're not aware of. And in times like this, such uncertain times, I think knowledge is the best armor we can have. Being aware is the best, I would say, best medicine for so many things. So thank you so much. Thanks a lot. And thank you, Shakthi, for this. And thanks to all the audience. I mean, great questions. I think I'm taking away a lot from here. So thanks everyone for being here. Once again, Vishnu, Vimala, Team Shakthi, thank you. Thanks.
Absolutely. And thank you, everyone. And thank you, Shakthi Corporation, for giving me this opportunity. And to again add the disclaimer again, it's not my motive to, if I had hurt anybody's feelings, anybody's religion, or anybody's basic norms that you've been following for a long time, that's not my motive. But because we are living in a country that everything is about paperwork and legality, I just want to make sure we understand it. And since it is easy to compare with India, because we come from a different country and we know about India's laws and rules. So I thought it is easy to compare Indian style of our living to the American style of living. And that's why I was comparing a lot of things. And my motive is not to hurt anybody's feelings or anybody's traditions here. So my apologies in case it has unknowingly hurt you. But on top of that, it is just our wishes to create an awareness about estate planning, because the laws are different in this country and we want to follow it. And thank you so much for this opportunity. And I'm happy that I'm able to share all of this. And I'm happy seeing people are aware of a lot of things that that wasn't there a few years ago. And I'm happy that we are following the trend and making sure we are doing everything right here. And thank you so much, everyone.
Thank you. Vimala, is it okay for us to ask people to, if we can get like a group shot, a screenshot?
Oh yeah, please. Yeah.
So if all of you are okay with it, if we could get, if this would be useful for us, for Shakthi, just so that we can spread awareness, let people know that we're doing these things, such sessions, and more people can join and be aware, and we're helping the community that way. So if you can turn on your cameras, please, and we can take a screenshot, whoever is willing.
Nice to see all the bright faces. Thank you for turning on. Good. Nice to see the faces.
Just 1 second, okay? Let me. Okay. Thank you, guys. Whoever's here, smile, please. Oh, we're still having people coming on. Okay.
Give her time to correct the faces, Vidya.
Yeah. Okay. I think I can, hold on 1 second. I'll probably have to take 2 because there are multiple shots on multiple Okay, all right. I just got one. Hold on, okay, guys. Sorry, I'm a little clumsy when it comes to these things. So just give me a minute. Okay, all right. Thank you. Thank you so much. Thanks.
Thank you so much.
Thank you.
See you all.
Bye.
Bye-bye. Bye-bye.
Presentation. Thank you so much. Thank you, Shakti Leadership, for organizing.
Oh, thank you.